Hi, my name is Trevor Crow, and I'm here to talk to you about securities implications of M&A deals. And this is a video about kind of rehashing a post that I posted on a blog post on biztaxbuzz.com. That's biztaxbuzz.com. So you can find out more information there. But let's get into it. So, attorneys are often engaged to advise their clients regarding the purchase or sale of a business, and these transactions are typically structured as either a purchase of assets or a purchase of stock, or there's a merger of some sort. Uh, so those are kind of the three structures that M&A deals typically start from. Now, often a portion of the purchase price may be paid to the seller in stock, stock of the purchaser. And so, while many practitioners are often focusing on their efforts on drafting the purchase or merger agreement and the ancillary documents that go along with those, there are many other issues to consider, and one of those is the securities laws, and that's an often overlooked issue. So, many times there can be a seemingly straightforward acquisition can have serious securities law implications. So, if not approached carefully, one of these simple acquisitions can land unsuspecting practitioner and its client in hot water with the Securities and Exchange Commission. Excuse me. And the focus of this sort of presentation is to make attorneys and counsel who counsel businesses regarding mergers and acquisitions, whether it's in-house counsel or outside counsel, aware of these securities law implications. First, I'm going to get into a kind of an overview of securities laws. And so the major federal securities laws are the Securities Act of 1933, that's typically called the Securities Act, and the Securities and Exchange Act of 1934, that's often called the Exchange Act. Now, the thrust of the Securities Act is to prohibit misrepresentations of fraud in and to ensure that investors receive all material information with respect to the offer and sale of securities to the public. The Exchange Act, on the other hand, is a system of mandatory disclosures for securities traded on the public markets and sets forth the periodic reporting and disclosure requirements for those issuers. So generally, the Exchange Act comes into play once a company goes public. Then they have the periodic reporting that they have to comply with, filing 10Ks, 10Qs, 8Ks, that sort of thing. Now, issuers that, like I said, become public and are subject to the Exchange Act, they have these quarterly and annual reports that I mentioned, and these are the SEC, the Securities and Exchange Commission, administers those rules. The SEC's mission is to protect investors, maintain fair, orderly, and efficient markets, and to facilitate capital formation. So one of the first questions to determine whether the securities laws are even implicated is there a sale of securities? So if there's a sale of a security, then you need to start thinking about whether the securities laws apply. And so it's well known that stock is a security, and that's defined in Section 2 of the Securities Act. But what's often overlooked is the transfer of stock incidental to a M&A transaction. So when a sale of a business and securities are being exchanged in that sale as part of the purchase price, that people often overlook that these securities laws are implicated, but they are. So in 1985, in fact, the U.S. Supreme Court held that securities laws would apply to a sale of a business through the sale of all or the outstanding stock of that business by stockholders. Now, prior to that Supreme Court case, there was what was thought to be some exemption if you were buying a business and going to have active participation in the business. And if you bought the whole business, even if you bought it through stock, that the securities laws wouldn't apply. But this 1985 case said that's not the case. So that has been put to rest. And that's a Landreth Timber Co. v. Landreth case. That's 471 U.S. 681. Again, Supreme Court case in 1985. So if there is a sale of securities, then the question becomes, have the securities been registered? If the securities are being transferred incidental to the sale of a business, they must fall under one of the exemptions from registration, or they must be registered under the Securities Act, which would require that the issuer file a registration statement with the SEC and pay a substantial fee to register the securities. The problem with that is the preparation of a registration statement is a time-consuming task, and it takes accountants, it takes lawyers, and there's a lot of fees that go along with that to prepare a registration statement. Generally, that's cost prohibitive and a big reason why people stay away from the registration statement. Further, the registration statements can take months to do. So when you're doing an M&A deal and you have deal momentum going, you generally don't want to take 2 months to several months to register securities. Along with that process, part of what makes it take so long is that the SEC will review and declare the registration statement effective, and so they'll take a look at it and they'll go back and forth with the issuer before it becomes effective. And this evaluation period by the SEC can cause a big delay. Once the securities are registered, the issuer becomes subject to public reporting and disclosure requirements of the Exchange Act. So then there's the other issue of being public and having to comply with all these rules and disclosure requirements of periodic reporting under the Exchange Act. That again requires the company to hire more attorneys and accountants and other professionals so they can meet those requirements, and that costs more money. So the big question is there exemption from the registration that applies to the deal? And really that's because, again, as I said, that due to the time and money involved with registering the securities, many times the deal has to get done under an exemption. Now, whenever you're looking at whether an exemption applies, there's two legal issues that must be addressed. One is which exemption from the registration requirements of the securities laws will be available to the company, and what type of disclosure will be required. And although there are many statutory exemptions from registration, you got to make sure that you have experienced counsel to review those, because the exemptions are narrowly tailored and strictly construed, so you have to comply to those to the letter. Most common exemption used for stock issued as consideration in a merger or acquisition is the private placement exemption pursuant to Section 4A2 of the Securities Act and Section 4A2 safe harbors that are in what's called Regulation D. A lot of people call it Reg D. And now, until recently, there was a restriction on it to comply with the exemption under Reg D. There was an exemption, or a prohibition on public solicitation or advertising, and that has been lifted just actually last week with the rules from the SEC, but through the Jobs Act. And so this video is not going to provide much information on that. That'll probably be a separate video, but I just wanted to put you aware of that there has been the Jobs Act rules from the SEC have been finalized, and so there are, under limited circumstances, you can or have a general solicitation and advertising. There are other issues with that, though, that you must comply with. So again, as I said, these exemptions are narrowly tailored and strictly construed, so you need to make sure that everything is complied with to the letter of the law. One of the other disadvantages of going through an exemption is that the securities that are offered are restricted, and so they're subject to resale limitations. You can sell. One of the other things that with an exemption under 482 is that you can sell to an unlimited number of accredited investors if they meet certain accredited investor standards, but only to a limited number of non-accredited purchasers or non-accredited investors, people who are getting this stock. So that's non-accredited is limited to 35, and it also increases the amount of disclosure they must provide. All right, so next topic is the blue sky laws. Now, blue sky laws are the states. Every state has their own securities laws, and so when you're looking for exemption, you got to not only find something federally, but you also have to find an exemption for the transaction under the blue sky laws. Pursuant to many of the state securities or blue sky laws, even if an exemption from registration can be found, a lot of times there's at least a notice of sale that that has to be filed with the state, so that's something to be aware of. Regardless of which federal exemption applies, a careful analysis of the residency of each potential offeree and of the states that they're in and their securities laws should be conducted before the transaction is consummated. Also, where securities will be transferred to non-U.S. citizens or entities, counsel outside of the U.S. may have to be retained to determine whether those are meet an exemption under the foreign law. Okay, so disclosure. What this topic is about, what sort of information you need to supply to somebody who is going to receive stock in an M&A transaction. So regardless of whether an exemption from registration applies, the exemption from registration does not exempt the offer or sale of securities from the anti-fraud provisions of both federal securities laws and the state securities laws. So what those say is basically you have to provide certain disclosures so that you don't so you don't violate those anti-fraud provisions. So where shareholders are entitled to vote on a transaction that will result in the receipt of another issuer's stock, the issuer must provide or make available, depending on what type of offering that's being made, to each offeree all available information that's material to an understanding of the company, its business, and the securities being offered, and the company must not make any material misstatements in connection with the offering. And so that's the general rule to not violate the anti-fraud provisions. Typically, this disclosure is made through drafting and delivering to the people that are getting the stock in the transaction what's called a prospectus / proxy statement. So it's kind of a combined. The proxy statement will be given to all the shareholders that are going to be receiving the stock, and so it provides information about the stock, the business, and everything that's involved with that without anything material needs to be put into that statement. Alright, so let's get into the resale of securities. Now, we briefly touched upon this earlier about restricted stock. If you sell securities through an exemption, this section is going to be about what happens if you have restricted stock. Alright, so securities issued pursuant to an exemption from registration or restricted securities, as I said before, they may not be publicly resold unless the shareholder complies with Rule 144, and if the issuer is not a reporting company under the Exchange Act, this would mean that they held the shares for at least 1 year. If the shares have been registered with the SEC, then they're not restricted and may be freely resold. So if you didn't go under an exemption and you were sold and the shares were actually registered in the deal, then they would be freely tradable. Subject to certain limitations on resales if people are affiliates or insiders, so that people getting stock who are also insiders to the company, there may be some restrictions there. And regardless of whether securities are registered, if the recipient of the purchaser of the share becomes an officer or director of the purchaser, which often occurs in an M&A transaction, that person may be deemed to have inside information, and then they'd have to comply with the insider trading laws. So they couldn't sell if they were in possession of material non-public information. All right, so let's talk a little bit about the penalties for violating securities laws. These penalties can be severe. A lot of times there's rescission rights and others, but let's get into it a little bit here. Liability for violations can be based on either selling unregistered securities without having an applicable exemption or engaging in fraud. So those are really the two big violations. Either you sold securities without registering and without meeting an exemption, or you sold securities and didn't provide all material information or omitted material information in your disclosure. So that would be engaging in fraud in the sale of securities. Under Section 11 of the Securities Act, issuers are liable if a registration statement contains an untrue statement of a material fact or omits to state a material fact required to be stated therein or necessary to make the statements therein not misleading. Now that's a quote from Section 11. It's not the best wording, but you get the picture that all material information must be disclosed. Section 12 of the Securities Act establishes liability for unregistered securities sales and creates purchasers' rights of rescission and establishes liability for fraud regarding the offer and sale of a security. Moreover, where unregistered securities are sold and the company fails to comply with an applicable exemption from registration, not only the company but also its officers and directors may incur severe civil and criminal fines and penalties. The conclusion on all this is that securities laws are very complex, and business acquisitions may have many securities laws implications which must be carefully considered before the transaction is structured, much less negotiated and consummated. And because of these serious penalties for violating securities laws, whenever there is an offer or sale of a security, whether in an acquisition or otherwise, securities counsel should be consulted to ensure that the issuer is in full compliance with the securities laws. This video here was not meant to be an exhaustive summary of the securities laws and should not be taken as such. Rather, it's meant merely to provide an overview of a few of the multitude of securities laws implicated by M&A transactions. So take it for what it's worth, and I thank you for sticking around. You can check out more on deallawyer.com. That's DEALLAWYER.com. That's going to be coming soon. It's going to be a membership website for M&A, offering M&A courses, podcasts, and articles for new M&A lawyers. You can also check out more on my blog, which, as I mentioned in the beginning, is biztaxbuzz.com. That's BIZTAXBUZZ.com. Thanks a lot.